Hi, I'm Brian Heidelberger, a partner with the law firm of Winston & Strawn in Chicago, and here today with another mini advertising law lesson. Today's law lesson, what the FTC's recent activity means to native advertising. But first, what the heck is native advertising? Brian, are you telling me that I have to learn something new on my lunch break? How dare you? Yes, I'm sorry. Today you're going to learn something new, and that is that 99.8% of banner advertising is ignored, and that is from a fact I got from the internet. But because of that, the advertising industry decided they needed to come up with something new, and that's native advertising. Think of advertorials. Think of branded entertainment or product placement. These are ads which are intended to blend in with a website to make the advertising less intrusive and more interesting to read. Think of BuzzFeed, who has an ad like this where it says 17 ways to make your desktop more delightful, and you see the Geico ads, but then when you get to the content, number 7 is decorate your desktop with little figurines, and you see a Geico figurine there. That is native advertising. And there's many other examples of native advertising that you'll see me posting right here. But let's talk about now what this means. Well, there hasn't been any law per se on native advertising, so we need to analogize from other things. The FTC has had recent activity which I think can provide us good guidance, and this is in the area of search engine and search type advertising. In 2002, the FTC had given guidance telling people you need to make it clear when it is paid advertising and not organic search results. And recently in June 2013, the FTC has again made that point and sent letters to a number of websites saying, listen, you've been slacking off on your distinguishing between paid advertising and organic results, and we want you to pay more attention. Now, what the FTC has said is you need to have very prominent shading, and you also need text labels making it very clear that this is advertising. Now, how does this apply, though, in the context of native advertising, which isn't necessarily search marketing? Well, the FTC, in a competitive news publication for advertising, recently is quoted as saying, regardless of context, consumers should be able to tell what's an advertising pitch and what's not. And that struck me as really strange. Is that saying that in native advertising, every native ad has to have a text label and some sort of shading? So I called Mary Engel, who is the woman from the FTC who is quoted, and she said, no, in fact, the news publication cut off the next sentence of her quote, which was, that is, unless the fact that the message is advertising is not material in a given context. And that, I think, is really important to think about in the context of native advertising. And it brings to mind branded entertainment in the FTC back in 2005 when they refused to adopt rules saying that branded entertainment or product placement needed a specific disclosure. And in that kind of case, we're talking about the Coca-Cola cup sitting in front of the judges on American Idol. And the FTC looked at that and they said, listen, we don't think a disclosure is necessary there because there is no objective product representations being made at that time. To the extent there is, a disclosure would be potentially necessary. But in most branded entertainment and product placement situations, there is no objective representation. And I think we can think about that for native advertising. If we're talking about just a placement like we saw in the Geico Gecko, well, then maybe no disclosure is more than the ad itself is really necessary because there no objective product representations are being made, and so disclosures aren't triggered. But when it's giving an opinion about a product or representing that the product can do X, Y, or Z, it becomes more important in native advertising to make the disclosure that this is not entertainment, this is advertising. Now, how do the FTC's guides for testimonial endorsements apply here? We saw a couple of years ago the FTC said that in the context of social media, if it's a paid-for opinion being given, you need to have a disclosure such as #sponsored or something of that nature. Well, the same could be applied to native advertising. But again, it goes back to what I was saying before. If it's not an opinion, well then it's not an endorsement governed by the FTC's guides for testimonials and endorsements. And in that kind of situation, no disclosure is probably required. It's really only required in those instances where you are representing it is the opinion of a third party when in fact it's not. It's really the opinion of the advertiser. What else has happened in native advertising? Well, the Atlantic magazine got in a little snafu when they placed an article that was really somewhat of an ad for Scientology, and the readership got up in arms. Even though they had a disclosure, the readership didn't believe it was clear enough. Obviously, the Scientology aspect turned this into sort of a hotbed. But you want to be very careful, not just to the legal issues, but also to the PR ramifications, which, as we all know, can sometimes be more important than the legal issues. And think about your audience and how they would feel if they feel fooled by some of your entertainment properties. That's it today for, oh, you like that voice there? That's it today for our mini law lesson, but please feel free to follow me at Brian Heidelberger for more mini advertising law lessons. You can find them on youtube.com/advertisingage or /Brian Heidelberger. And until next time, let's be careful out there.